The matter of MS Tomorrowland Limited versus Housing and Urban Development Corporation Limited and others, Supreme Court partly allowed the appeal and held that the material on record sufficiently indicates that the appellant did not approach the court with clean hands and instead attempted to hoodwink the judicial process by creating a facade to subterfuge the inability to meet their contractual obligations. We are constrained to observe that the intent of the appellant throughout appears to be that of prolonging the litigation to cloak its impecuniousness. Ministry of Urban Development, Government of India had decided in 1990 to develop an area of 71 acres of land located at Andrewsganj, New Delhi. Bids were thus invited for the properties at Andrewsganj, offering land which was to be leased for 99 years in order to establish a five-star hotel along with already built car park, 9 guest house blocks, 9 restaurants, and 25 shops already constructed, and a shopping arcade and a cultural center to be built by the successful bidders. The scope of the appeal was restricted only to the item number 1, which is land that was to be leased for 99 years in order to establish a five-star hotel along with the already built car park. This was the subject property. Supreme Court said that it needs no emphasis that whosoever comes to the court claiming equity must come with clean hands. The expression clean hands connotes that the suitor or the defendant have not concealed material facts from the court and there is no attempt by them to secure illegitimate gains. Any contrary conduct must warrant turning down relief to such a party owing to it not acting in good faith and beguiling the court with a view to secure undue gain. Court of law cannot be the better of inequity by siding with the party approaching it with unclean hands. This also brings to mind the often quoted legal maxim, he who seeks equity must do equity. We are conscious of the fact that, as a general principle, in commercial disputes, the award of interest pendente lite or post decree is typically granted as a matter of course. This is because such interest serve to compensate the aggrieved party for the time value of money that was due but withheld during the legal process. It reflects an established norm aimed at ensuring fairness and equity in commercial transactions. In the instant case, which is fit to justify a deviation from the established standards, in the facts and circumstances, respondent 1 was held to be in breach of several contractual obligations. The conduct of the appellant was rife with instances where it also sought to undermine the authority and integrity of the judicial process by treating the court with disregard and attempting to exploit procedural mechanisms for personal gain. Thus, it was held that in view of these reasons, the appellant was not entitled to any discretionary relief of interest under Section 34 of CPC. Hudco was in breach of its reciprocal contractual obligations, thereby disentitling them from forfeiting the monies already paid by the appellant towards the first installment. Given that appellant had blatantly engaged in forum shopping and conceding their overall conduct does not reflect an approach aligning with the clean hands doctrine, they were not entitled to grant any discretionary relief of interest in their favor.